and you have been seeing posts online claiming that new rules will prevent you from getting loans, buying a house, or accessing credit simply because of your immigration status, or that the government can now deny your green card application based on whether you have taken out loans or used certain financial services, I understand that you are confused and worried because the information circulating about these supposed green card loan restrictions is vague, contradictory, and often presented in the most alarming way possible without clear explanations of what is actually changing and who is truly affected. You deserve factual information about what these green card rules actually say, whether they involve restrictions on loans or financial access, who is affected and who is not, what the actual legal requirements are, and what you should be doing right now to protect your immigration status and your financial future. Welcome to Immigration Law Alerts, where we give you U.S. immigration information that is calm, accurate, and completely free from the political spin and fear-mongering that is making people panic about changes that may not even apply to them. Let me start by clarifying something extremely important. There is significant confusion online right now about what these so-called 2026 green card rules involving loans actually are. Some of the confusion comes from mixing together different immigration policies, some comes from misunderstanding existing rules, and some comes from speculation about policies that have not actually been implemented. Before I explain what is real and what is not, I need to establish a foundation of how U.S. immigration law currently treats financial matters and public benefits so you understand the context. U.S. immigration law has long included what is called the public charge rule. This is not new. The public charge rule has existed for many decades, and it essentially says that the U.S. government can deny green card applications or visa applications to people who are likely to become primarily dependent on the government for their financial support. The idea behind this rule is that immigrants should be self-sufficient and should not need to rely heavily on government welfare programs. Over the years, different presidential administrations have interpreted and applied the public charge rule differently. Some administrations have applied it very strictly, considering a wide range of government benefits and financial factors when deciding whether someone might become a public charge. Other administrations have applied it more narrowly, focusing mainly on cash welfare assistance and institutionalized long-term care. These policy shifts create confusion because people hear about changes to the public charge rule and they are not sure what the current version actually requires. Now let me address what is actually happening in 2026 regarding green card rules and financial matters. As of the time I'm recording this video, there is no specific new rule that directly restricts green card holders or green card applicants from taking out loans. Let me say that again clearly. There is no policy that says green card holders cannot get mortgages, car loans, student loans, credit cards, or other standard financial services. Green card holders have the legal right to access financial services in the United States, just like U.S. citizens do, and lenders make decisions based on creditworthiness, income, and standard lending criteria, not based on directives from immigration authorities telling them not to lend to immigrants. However, there are aspects of immigration policy that relate to financial matters and public benefits, and this is where confusion is arising. Let me explain these carefully. First, when you apply for a green card through most family-based or employment-based pathways, you may need to demonstrate that you will not become a public charge. This typically involves showing that you have adequate financial support either through your own income and assets or through an affidavit of support from a sponsor who agrees to financially support you. The affidavit of support, which is Form I-864, is a legally binding contract where a sponsor, usually a family member or employer, agrees to support you financially and promises to reimburse the government if you receive certain public benefits. This form requires the sponsor to meet certain income requirements, typically at least 125% of the federal poverty guidelines. This is not new, and this is not a restriction on loans. This is a requirement to show you have financial support when applying for your green card. Second, receiving certain types of public benefits while you're a green card holder can potentially affect your eligibility for citizenship later, or in rare cases could raise questions if you travel internationally and seek to return. The public benefits that are most concerning from an immigration perspective are cash welfare assistance programs, such as temporary assistance for needy families, commonly called TANF, and supplemental security income, known as SSI, as well as long-term institutionalized care paid for by the government. Using these benefits extensively can raise questions about whether you are self-sufficient. However, many public benefits are not considered problematic for immigration purposes. For example, emergency medical care, public education including public schools and state universities, immunizations and testing for communicable diseases, and disaster relief are generally not counted against you. Additionally, benefits earned through your own work contributions, such as Social Security retirement benefits, if you paid into the system, Medicare, if you are eligible through work history, and unemployment insurance if you paid into the system, are not typically held against you. Now, let me address the specific rumors about loan restrictions that are circulating. Rumor 1, green card holders will no longer be allowed to take out mortgages or car loans under new 2026 rules. This is false. There is no immigration policy that restricts green card holders from accessing standard consumer loans. Lenders may have their own underwriting criteria that could make it harder for people without long credit histories or without stable income to qualify for loans, but this is a lending decision, not an immigration restriction. Rumor 2, if you take out student loans to pay for college, this will be counted as receiving public benefits and will hurt your green card or citizenship application. This is misleading and mostly false. Private student loans are not public benefits at all. Federal student loans, such as those offered through the Department of Education, are government loans, but they are loans that you repay, not welfare benefits. Taking out federal student loans that you are eligible for and that you repay does not typically count against you for immigration purposes. However, if you default on federal student loans and the government has to absorb that debt, this could potentially be an issue, though this is rare. Rumor 3, USCIS is now checking whether green card applicants have any debt and denying applications if you owe money. This is an exaggeration. USCIS does review your financial situation as part of assessing whether you are likely to become a public charge, but having some debt such as a mortgage, car loan, or credit card debt is not automatically disqualifying. What matters is whether you have sufficient income and assets to support yourself despite your debts. Many people with mortgages and other debts are approved for green cards every year. Rumor 4, green card holders who have received any government assistance at any time can now have their green cards revoked. This is false and exaggerated. Green card revocation is an extremely serious action that requires a legal process and typically involves fraud, criminal activity, or abandonment of U.S. residence. Simply having received some public benefits in the past does not result in automatic green card revocation. However, if you receive benefits fraudulently, or if your use of benefits demonstrates you were never truly self-sufficient when you obtained your green card, this could potentially be an issue in extreme cases. Now let me explain precisely who might be affected by public charge considerations in 2026. People who are currently applying for green cards through family-based immigration or certain employment-based categories need to demonstrate they will not become public charges. This means you need to show adequate financial support through the affidavit of support form or through your own income and assets. If you cannot meet this requirement, your green card application could be denied. People who are green card holders and who are planning to apply for U.S. citizenship should be aware that extensive use of cash welfare benefits could potentially be relevant to the good moral character assessment in citizenship applications. However, this is not an automatic bar, and many people who receive some benefits during difficult times have been approved for citizenship. People who are green card holders and who travel outside the United States for extended periods and then seek to return should be aware that heavy reliance on public benefits while outside the United States or immediately after returning could raise questions at the border about whether you truly maintain U.S. residence. Now let me explain who is not affected. U.S. citizens are not subject to public charge rules at all. Once you are a U.S. citizen, your use of public benefits or your financial situation does not affect your citizenship. Green card holders who have maintained their status properly, who have not engaged in fraud, and who have not abandoned their U.S. residence are not at risk of losing their green cards simply because they have taken out loans or have some debt. Refugees and asylees are generally exempt from public charge determinations when they apply for green cards. Let me now address what you should actually do depending on your situation. If you are planning to apply for a green card in 2026, work with your sponsor to ensure the affidavit of support form is completed properly and that your sponsor meets the income requirements. If your sponsor does not meet the income requirements on their own, consider whether joint sponsors or household members can contribute their income to meet the threshold. Gather documentation of your own income, assets, and employment to demonstrate your ability to be self-sufficient. If you are a green card holder and you are concerned about how your use of benefits might affect your status, first understand that using benefits you are legally eligible for is not automatically a problem. If you are facing financial hardship and you need assistance, do not avoid seeking help out of immigration fear if you are legally eligible. However, if you are planning to apply for citizenship in the near future and you have been receiving cash welfare benefits extensively, consult with an immigration attorney about whether this might affect your citizenship application. If you are a green card holder and you are considering taking out a mortgage, car loan, student loan, or other standard financial product, proceed with your financial decisions based on your financial situation and your creditworthiness. Immigration law does not prohibit you from accessing these services. Make sure you understand the terms of any loan you take out and ensure you can afford the repayments, but do not avoid these financial tools simply because of unfounded immigration fears. If you are applying for U.S. citizenship and you have used some public benefits in the past, be prepared to explain your situation honestly on your N-400 citizenship application. USCIS will ask about your use of public benefits and you need to disclose this truthfully. However, having used some benefits does not automatically disqualify you. Be ready to explain the circumstances, show that you are now self-sufficient, and demonstrate your good moral character in other ways. Now let me explain how the affidavit of support actually works because this is central to understanding financial requirements for green cards. When a U.S. citizen or green card holder sponsors a family member for a green card, they must file Form I-864, the Affidavit of Support. This form is a legally enforceable contract. The sponsor agrees to provide financial support to the immigrant and to reimburse the government if the immigrant receives certain means-tested public benefits. The sponsor must demonstrate income at least 125% of the federal poverty guidelines for their household size. For example, if the sponsor has a household size of 2 people, including themselves and the person they are sponsoring, they need to show income above a certain threshold that is updated annually. If the sponsor does not meet the income requirement through their own income alone, they can use assets, they can use income from household members, or they can find a joint sponsor who also files an affidavit of support. The affidavit of support remains in effect until the sponsored immigrant becomes a U.S. citizen, has worked 40 qualifying quarters of work, approximately 10 years, in the United States, dies, or permanently leaves the United States. This means the sponsor's legal obligation continues for many years, and sponsors need to understand this is a serious commitment. Now let me address the difference between public charge determinations and the restrictions that actually exist versus the rumors. The public charge rule does not prohibit green card holders from taking out loans. It does not require green card applicants to have zero debt. It does not disqualify people who have ever used any form of government assistance. What it does require is a showing that you are not likely to become primarily dependent on cash welfare or long-term government care. USCIS evaluates public charge using a totality of the circumstances test. This means they look at your entire situation, including your age, health, family status, education and skills, financial assets and resources, and whether you have an affidavit of support from a qualifying sponsor. Having some negative factors does not automatically result in denial if you have many positive factors. Let me also clarify the role of credit reports in immigration applications. USCIS does not routinely check your credit report when you apply for a green card or citizenship. They are concerned with your financial ability to support yourself and your use of public benefits, not with your credit score or your debt-to-income ratio. However, if you submit financial documents such as bank statements, tax returns, or employment letters as part of demonstrating your financial situation, these documents will be reviewed. Before I close, let me address some common specific situations people ask about. If you are a green card holder and you want to buy a house with a mortgage, this is completely fine from an immigration perspective, and lenders will evaluate you based on your income, credit, and standard lending criteria. Having a green card generally makes you eligible for most mortgage products that U.S. citizens can access. If you are a green card holder and you are taking out federal student loans to attend college, this is generally not an immigration problem. Student loans are loans you repay, not welfare benefits. Make sure you repay them according to the terms. If you default, this could create financial and potentially immigration complications, but using student loans appropriately is not problematic. If you are a green card holder and you lost your job and you need to apply for unemployment benefits that you paid into through payroll taxes, this is generally okay. Unemployment insurance is an earned benefit based on your work contributions. However, if you remain unemployed for very long periods and you begin receiving cash welfare assistance beyond unemployment insurance, this could potentially raise questions if you later apply for citizenship or if you travel and return to the United States. If you are applying for a green card and you have significant assets such as property, savings, or investments, even though your income is low, you can use these assets to help meet the public charge requirement. Assets are typically counted at 1/5 of their value toward the income requirement, meaning if you have significant assets, this can compensate for lower income. Let me remind you that immigration rules rarely change overnight, and due process exists. Public charge rules have existed for a very long time, and while the specific interpretation and application of these rules can shift between administrations, the fundamental principle that immigrants should be self-sufficient has been consistent. If you are applying for a green card or citizenship, Work with qualified professionals to ensure you understand the current requirements and that you present your financial situation accurately and favorably. If this video helped you understand what the 2026 Green Card rules actually say about financial matters and loans and clarified the difference between real requirements and unfounded rumors, I would appreciate it if you subscribe to Immigration Law Alerts and turn on notifications so you receive accurate U.S. immigration information. Share this video with anyone who is confused or worried about Green Card loan restrictions. And if you have questions, leave them in the comments. While I cannot provide personal legal advice, I can address common questions in future videos. Thank you for watching, and remember, Green Card holders can access standard financial services. Public charge rules focus on self-sufficiency, not on debt. Consult with immigration attorneys if you have complex financial situations, and do not let social media rumors cause you to make poor financial or immigration decisions.